This court job here, give attention and you should be heard. The Honorable Judge Jones, God, please be seated and no talking.
Good morning, Judge.
Good morning, Judge. Good morning, everyone. Now the court. You saw. All right, before we get into the trial matter, it appears, and this is for our media guests, it appears we're having a lot of interference as far as Bluetooth and Wi-Fi. We are going to need to be able to use the Bluetooth capabilities to be able to show the videos. So I know that there may be many of you all using devices that are using Bluetooth. We have the mics here. I understand we are doing some streaming and video pools, but we're going to need to minimize the use of any Wi-Fi or Bluetooth devices inside. So if it becomes a problem, we're going to end up having to restrict that use outside of the microphones and video. So please, if you do not need your Bluetooth or wireless device on using the Wi-Fi or Bluetooth, please turn it off so that we can minimize that burden and hopefully not have any interruptions. If we have interruptions, then the court's going to need to end up having everyone shut their devices off. So please, if you do not need it, please go ahead and turn that off so we don't have any interruptions. All right. Now, we are here on indictment 2300241, the trial matter State of Tennessee versus Tadarius Bean, Demetrius Haley, and Justin Smith. Before we bring the jury in, the court understands there's some preliminary matters. All right, we start with the state.
Everybody was working yesterday, and there's motions in limine filed by defense, and there's motion in limine to bring to your court's attention this morning from the state. Start with the motions in limine filed by defendant Haley. He had filed a motion in limine regarding photographic evidence, pictures taken of Tyre Nichols at the hospital after this incident. We have culled through those pictures with defense counsel, and we have agreed to limit that evidence to one picture. And I think defense counsel is going to withdraw that motion in limine with regard to that.
Is that correct?
That's correct, Your Honor.
All right, we'll show that motion withdrawn.
Mr. Haley filed a motion in limine regarding certain statements made on a response to resistance form. I apprised Mr. Haley's counsel in particular yesterday that we will not need to litigate that motion because we do not plan to introduce that form in our case in chief.
That's correct, Your Honor.
All right, so we'll show that motion withdrawn.
He filed a very lengthy motion that I think makes reference to at least 13 or 14 different statements that Justin Smith made in a proffer interview, as well as statements that co-defendant Bean made in a proffer interview. One is that defendant Bean had called Haley a kicker, someone who kicks. One had been Bean's opinions regarding Haley's kick that we'll see on the video. One had been a statement that Bean had made about Haley sending a picture to Justin Smith after this incident. One had been a statement Bean made about a conversation between Haley and Mills about Mills's body-worn camera. With regard to all those things I just mentioned, I apprised them yesterday that the state does not intend in its case in chief to introduce any of those statements with regarding to Bean's opinion about Haley's kick or Bean's opinion about some conversation or whatever it is. And those were the ones relating to Bean. A motion in limine seeking for the state not to introduce evidence of prior conduct of Haley in our case in chief. Apprise them that we are not intending to introduce prior conduct of Haley. Statements of Smith now, like Bean. Smith had given a statement that Haley liked to chase cars and was on a team that they called the indictment team because they were expecting indictment. Smith had made a statement that he was of the opinion that Haley was a hothead. Smith had made a statement that Haley always knew people on the scene and I guess on the scene of other crimes or other situations. He had also made a statement on his opinion as to how Haley got on the Scorpion team in the first place. Smith had made a statement that Haley does not like wearing his body-worn camera. Smith had made a statement that Haley is a loose cannon. Smith had made a statement about a prior incident in which Haley had punched a suspect. Smith had made a statement about Haley watching a body-worn camera prior to arrest and getting mad. Smith had made a statement about Haley being referred to as uncontrollable chaos. Smith had made a statement about Haley kicking the suspect. Smith had made a statement about not being able to watch the body-worn camera once it was released to the press. All those statements I just mentioned of Smith's, we do not intend to introduce in our case in chief.
Has the witnesses been advised not to speak on those points?
They will be.
Okay.
They will be before they testify, Your Honor. And obviously, I'm not going to make mention of any of these things. We're not going to use our case in chief in an opening statement or anything like that. I'm going to skip one and come back to it. Smith had made a statement that days after the incident, Haley had admitted to kicking Tyre Nichols. Smith had made a statement that he had called Martin and told him that Haley had told him that he had kicked Nichols. Smith had made a statement that he had called Dwayne Smith and told him that Haley said he had kicked Nichols. Smith had made a statement that after he watched the video that he could see that he was being used as a quote stand in our case as a quote stand during the incident. And Smith had made a statement giving his opinions about other people's conduct in our case in chief. We're not seeking to introduce any of those statements or conclusions or Smith's impressions of the body cam or the poll camera, so we'll not use those statements either. There is a statement with regard to Smith, and I do not know that we need to litigate this right now because I'm not going to make reference to it during an opening statement, and neither one of the witnesses expected to testify today know nothing about this statement. They're not the relevant witnesses. But Smith does make a statement after watching the poll camera that it is his conclusion that, I may get the exact quote wrong, but that nobody, presumably to include himself, did anything right on the scene. Speaking of the beating of Tyre Nichols, that is a statement that the state would submit as an admission and should be admissible if the state chooses to call that witness. Again, I am not going to make a reference to it in opening statements. I think that we could put that on pause. In the interest of time, we can litigate that before that witness testifies need be. That would be my suggestion.
Any issue with that? Any issue with that?
Your Honor, no, there was one that, I don't know if it was inadvertent, number 5 on Bean. You didn't bring that one up, I don't think.
Okay, there's another, I may have missed, there's another statement by Bean that describes a prior incident.
Correct.
That's listed as filed in the motion to eliminate. The state does not intend to elicit any proof on that.
All right.
In its
So-
case in chief.
With that, Your Honor, I don't believe there are any more issues, except the one potential issue that has been withheld, on the statements of co-defendants.
All right, well, we will go ahead and reserve that one point for that witness, should it be needed to be litigated, we'll do that at that, point. But we'll go ahead and show, at least for now, this motion being, withdrawn.
There are 5 other matters, I believe, Your Honor, that made counsel aware of yesterday. Oh, that's right. There is another motion by defense.
Correct.
That we haven't spoken about, and I'm not gonna speak for defense. Let me introduce the issue, and then defense can speak for itself on it. We will see evidence during the trial that Defendant Haley, after the beating of Nichols, takes a picture of Nichols on his cell phone. That cell phone was retrieved by TBI. There was a consent to search it. TBI agents found that photograph that Haley had taken of Nichols right after the beating. They found that Mr. Haley had sent that picture to numerous people. They found text messages related to the sending and receipt of that picture. My understanding, and again, I'm just trying to introduce their motion. If it's different than what I think it is, then they'll tell Your Honor. My understanding, there's a motion in limine with regard to one text exchange surrounding that picture that Defendant Haley took. And then there may be, I'll let counsel speak for himself, a separate motion having to do with the picture itself.
All right, Mr. Leffler.
Your Honor, may I pass the picture forward for Your Honor?
Yes, sir.
Thanks. This is the photograph that the state was just discussing, Your Honor, and in my motion, one thing that I offered to do in the motion was to stipulate to the contents of the photograph being stated, and what I put in the motion was, in the photograph, his face is bloody and sweaty, his hands are cuffed behind his back, his clothing is disheveled and soiled. The lighting gives the photograph a stark appearance. The photograph is disturbing and hard to look at for very long. There will be substantial video admitted into evidence which likewise depicts Mr. Nichols at this same time period. We are objecting to the photograph itself coming in, but we're not objecting to a description of it that is substantially similar to the one that is made. And in Tennessee, the courts have said that the state's burden of justification is often difficult to sustain when the objection offers at the same time to allow a description of the photograph itself.
All right, state the all
Now, this is perhaps the most direct proof. In this case, the allegations are that they beat Mr. Nichols to death. This is immediately after the beating stopped and he was put on the car, but the kidnapping continued. It's the argument of the state that obviously he suffered serious bodily injury by the beating, and ultimately he was killed by the beating. The argument of the state is also that at some point during this incident, his detention became unlawful. And one of the ways in which it became unlawful is the officers put him on the side of the car, handcuffed, extremely injured, knowing at that point that he was a victim of police brutality, yet they did not inform medical personnel of head trauma or any impact to the head. I think this picture also goes to Mr. Haley's intent in that kidnapping, and I think it goes to his consciousness of guilt with regard to the crimes. I think it's extremely probative. I think it's extremely relevant. Is it a violent, is the image graphic? Of course it is. We're here for a very graphic crime, but I'd ask Your Honor to admit it.
Matt, respond. Mr. Haley would have no way of knowing that there had been any head trauma to Mr. Nichols because Mr. Haley was not there when that head trauma was inflicted on him. Also, Your Honor, I don't believe that this photograph would be consistent with the state's response to our motion for bill of particulars, in which it isolated the incidents that the state was going to be relying on to the physical contact that occurred with Haley at Castlegate.
Explain to me again the issue with regard to the bill of particulars. What's the argument with regard to
The bill of particulars, I believe the response of it was that what the state was relying on was what happened. Let me give you the exact wording, Your Honor. Yeah, Your Honor, in the state's response to the bill of particulars, it said, put plainly, the state alleges that these defendants, while they were armed police officers sworn to serve and protect, beat Tyre Nichols, restrained him while he was on the verge of death, and lied to medical personnel about his condition. As a result of this, he died, and then it sets forth murder, second degree, count 1, aggravated assault, acting in concert, count 2, and official misconduct, count 5. Further, during the course of this, his detention and continued confinement, even if arguendo, it started lawfully, it became unlawful confinement, detention and mistreatment, and caused serious injury, all accomplished by armed police officers, and it cites counts 3, 4, and 7. This photograph would not be included under any of that the state set forth in their response to the motion for bill of particulars.
All right, State, you want to respond?
There's a motion for bill of particulars. There's obviously an initial incident, and there's a second incident. And the state has always said, just like it says in its motion for bill of particulars, that we're not alleging. There very well may have been, so I don't want to be misquoted, there very well may have been illegal activity at that first scene when Mr. Nichols is stopped and pulled from the car, but the state's not alleging criminal conduct from the first scene. The state's alleging criminal conduct at the second scene, which extends from the time that he was brought to the ground till the time that he was transported in the ambulance to the hospital. This picture was taken right there in that time frame when he's seated against the car at the second scene, handcuffed and just having been beaten. His illegal confinement is literally a picture taken of him while he is illegally confined. So I mean, it's entirely apt and on point.
You do want to respond?
Your Honor, during the entire time that the state was talking about, Mr. Haley was still at Ross and Raines, the first place where they had contact with Mr. Nichols. He never made it from there until just prior to Mr. Nichols, or just prior to Mr. Nichols getting handcuffed at Castlegate.
Well, listening to the arguments, it sounds as though the photo in which it was taken, the time in which it was taken during the second incident, or the second scene, falls within that window the state was referencing. With regard to the content of the picture obviously is a graphic picture. The court would not necessarily describe it as a overly gruesome picture, in which that would need to be withheld from the jury transmitted via text to multiple parties after the incident would go towards the argument of the mental state of the defendants involved in transmitting this picture. And so where it stands right now, the court is not going to withhold this or deem it inadmissible. The court will allow this picture to be presented should the proper foundation be laid at the appropriate time.
Thank you, Your Honor.
There's a second half of Mr. Leffler's motion with regard to this picture. Mr. Haley sends this picture to numerous people. One of the people that he sends it to responds with a text message that's in Mr. Haley's phone, and I don't have it in front of me, so if I misquote, but it is short. Who beat him up? To which Mr. Haley responds, I believe, again, I don't have it in front of me, all 6 of us. So I think he has a motion in limine also with regard to that.
Yes, Your Honor. You're ready for me?
Yes, sir.
Your Honor, that was an email, a text message exchange with a gentleman named Fox, F-O-X. Mr. Haley in the text message exchange does not say anything about beating anybody up. That was the words of Mr. Fox. That would be hearsay. We would not be able to cross-examine Mr. Fox on what he meant by that and under what circumstances. Is that the only text message that you would plan on?
Yeah. And then, I left something out. Mr. Haley, Mr. Leffler also filed a motion with regard to a couple other text exchanges surrounding this picture. So let me go ahead and put these on the record here. This is a text message between Haley and a third party that's labeled Exhibit 2, in which he asked her to delete the photo off her phone, and she responds that she already had. The state's not going to introduce that in its case in chief. The text message between Haley and another third party in which he asked her to delete the photo from her phone. The state's not going to introduce that. The text message between Haley and another third party in which Haley makes a statement, F the N-words, I hate my own race. This was sent well in advance of the Nichols case, and the state does not seek to introduce that text message. A text message sent to another police officer in which he later apologized for sending the photo because he says he did not intentionally send it. The state does not seek to introduce that. But then the one the state does seek to introduce as far as the substance of the text exchange is the one in which the third party asked who beat him up, and Haley responded, "We did, all 6 of us." That is the text message you're talking about.
Yeah. So thank you for that. And the only one I'm talking about there is the one I've already addressed to the court. That's our position.
All right, so, I mean, would you not agree though by, I guess, affirming or responding to it that it's adopting what that previous statement was? I mean, obviously he didn't make the statement, I did this, I beat someone up, but when asked who did, and he just responds, we did. I mean, the court would find that is adopting that statement as far as an admission. And so the court, if there is the proper foundation laid in that with regard to hearsay, the court would find that to be an admission of the party. And so the court would not withhold that statement, at least on that basis, unless the state were to not lay the proper foundation should admit it. Yes,
Judge, maybe you heard briefly on that. I think I may or may not have, I think I may have joined in his motion as it relates to the statement the 6 of us did.
Yes, sir.
Well, to to say that that would be confusing, misleading to a jury of who those 6 are, and an admission that he's making on behalf of 5 other unknown people, I mean, that's a real stretch. And so I'm just saying that from its probative value, the 6 of us did. What 6? I think people start getting lumped into a boat based upon Haley's alleged admission against himself. Now, if that wants to be used against him and the judge rules that way, you rule that way, so be it. But I think there's only 5 defendants, 3 of them here. I mean, that just causes all sorts of confusion, and it's unfairly prejudicial to Mr. Smith, who may not even be who Haley meant in that text. If Haley's not going to take the stand in order to explain what the 6 of us means, I think admitting that would be unfairly prejudicial to the other people. That's just my position.
State the other response.
Well, I think a couple of things. I think Your Honor can instruct that this statement of Haley goes to Mr. Haley as an admission on behalf of Mr. Haley and not to the co-defendants. If the issue is 6, the number 6, or, okay.
I think you dealt with it. If the court will limit instruction in Haley, if you admit it, that's an admission as to Haley and not any other party. Mr. Hagerman, I agree.
No.
Is that right, Mr. Hagerman?
All right, if the proper foundation is laid, then the court would give that limited instruction as far as this being a statement from Mr. Haley and referencing his potential involvement, and the court will give the instruction that there's that be limited to Mr. Haley as he being the author of that statement. But again, that will be dependent on the proper foundation being laid to get to that point. But where we stand now, the court would allow for that statement to be in with regard to Mr. Haley.
Thank you.
Any other matter?
I believe there are some oral motions in limine that we're gonna have a position on.
All right.
There are, now I'll just start with the first one. As I said, these are in no order. The state files a motion now to limit the mention of any sort of civil proceedings or the details of any sort of civil suit or hearings or anything that may have happened during the course of civil litigation. I know these attorneys are very well versed in the civil litigation because they're part of it. But I don't think any of the civil proceedings have any relevance to the proceeding, obviously the criminal proceeding that's before the court. Now, obviously, if there's witnesses that have given depositions in civil proceedings, I'm not seeking to limit their impeachment, like I understand and maybe impeached by prior statements they gave in civil proceedings. But the fact that there's a civil proceeding pending and what its status is and what's going on or has gone on it, I would submit as of no relevance to any criminal issues before the court.
Any issue with that?
Have you heard? Are you gonna make us go that thing back in order again? Okay, well, Mr. Hager's gotta go first.
No, just one for.
Ms. Hadley, so.
All right, so we'll go ahead and just establish our order now, so Mr. Perry.
Yeah, as it relates to the limiting motion regarding it, I vehemently would ask that the court deny that at this particular point in time. Prove from us what's going on in a civil case could possibly go to bias, go to motive to testify a certain way. None of those issues right now have been fleshed out, and I think that to at least make that motion or to grant that motion at this point would be premature. We will receive this information. Well, I received it yesterday evening. I was looking at emails and spent the day preparing, but I didn't go through the emails, at the time that I guess they were being sent. So that was the first time that we saw it. It doesn't quote any particular law that says that is innately illegal to go into. There's nothing that shows how the probative value is outweighed by a prejudicial effect to mention what's going on in a particular civil suit. If you bring the right witness that has a motive, a pecuniary motive in the case to testify a certain way, then I think that we should have the ability to cross-examine and confront that witness based off of that information. So at this time, as it relates to a motion in limine regarding it, I think that is inappropriate.
All right.
Your Honor, if I were to make reference to the civil proceeding, it would be something along the lines of, do you recall giving testimony in another in a related case, not say in the civil proceeding or anything like that. But there are things that are in there that could be used as impeachment, prior inconsistent statements, things of that nature. I would do everything that I could to not bring up the fact that there is a civil proceeding, and I think it can be done. However, if the witness is not understanding some of the things that I'm referring to, I may have to get closer to the edge of there being a civil proceeding. So that's our concern.
Not right. Mr. Zimmer.
Judge, I just want to be real clear that what Mr. Perry said is what my position is on this, not what Mr. Leffler said. Why are we dancing around such a huge issue of a $550 million lawsuit against the city of Memphis? When, Judge, the proof will be that we believe the investigation about the TBI and the DA's office was corrupted from the start. And we will have evidence that Mr. Crump's office, plaintiff lawyer, directed Mr. Mulroy, Mr. Hagerman, Ms. Headley, to take, for lack of a better word, a deposition of Preston Hemphill. And it didn't have one thing to do with Tyre Nichols. It had to do with the Scorpion team, pulling black people over, roughing them up. And it was at the direction of the plaintiff lawyer writing to Steve Mulroy saying, hey, we'd really appreciate it if you could ask these questions. So they called Lee Gerald, and they called Mr. Hemphill in. Mr. Hemphill had a cooperation agreement. So he comes in thinking it's going to be a proffer, and he sits there and basically is deposed, and it's transcribed. And that transcript is then provided to Ben Crump's office. And do we think for 1 minute that that type of influence by a plaintiff lawyer might affect what the TBI agents are out there doing, what the TBI agents coordinate with the DA's office to do? Well, part of our proof is going to be this was not a fair investigation of these officers. It was one-sided, and that civil litigation will come in that way.
Well, I think though, the state has already acknowledged that there may be certain circumstances and situations in which the civil case may be relevant, but as far as the civil case just being out there, and it's not relevant to anything that we have going on. There may be certain situations and instances where impeachment may be at issue, bias or motive to lie may be able to be presented, but we're not going to try the civil case over here.
Oh,
And so as far as all of the other things that are just plainly part of that suit, we're going to leave over there. What I would suggest, and my position is, outside of impeachment, outside of bias or motive or something along those lines, then it has no relevance to this matter. Now, if as the proof is coming on, you all discover something or believe something has occurred which now expands that relevance, then we can approach and we can discuss and make a determination at that time. But I want to go into it with the understanding that we are not going to go into the civil matter unless it's for those purposes of impeachment or bias or motive or things of that sort. Again, if as we go through that proof, if you all feel some door has been opened and that we need to go through it, then we can have a jury out hearing and we can discuss that and make that determination. But where we stand now, the court's just going to limit the questions for the purposes of impeachment or bias or motive or things of that nature.
I'll go out of order from my list here because this seems to be a natural sort of progression. Filed a motion in limine with regard to the mention of the federal trial or any of the verdicts in the federal trial. I suggest that when we're referring to the federal trial during impeachment, that the attorneys call that a prior hearing in the matter. If needed, a prior hearing in which these prosecutors weren't present, something like that if needed, to explain. Again, not trying to keep it out for impeachment. If these witnesses testify differently in federal court, understand that they can and will be impeached by their testimony. But the fact there was a federal criminal trial with regard to these defendants, or whatever the results of that federal criminal trial were, I believe are entirely irrelevant to the criminal proceedings here.
To paint a complete picture, lying at a deposition is somewhat different than lying before a federally impaneled jury who's looking you eye to eye and you give an inconsistent statement. So that said, I don't know how to dance around that issue. Now, as far as me saying that we prevailed on the civil rights case or things like that, I can understand how the court's position on that would be. But I want to look this witness directly in the eye. If he takes the stand, he's given 2 inconsistent statements already. I'm thinking about the witness that they're going to call later today. One of them is directly opposite of the other one. One is before people that he's not sworn to, that he's just doing it to keep his job possible. The other before a federally sworn and impaneled jury. That makes a huge difference. And if he's willing to give an inconsistency there, then this jury needs to know that. Now, I don't, like I said, once again, to paint a picture about what the verdict would have been and things like that, I don't plan to do anything along those lines. But I do want to be abundantly clear. It's less than fair, and we're going to get into this argument, I think, on one of their motions in limine regarding our ability to cross-examine regarding how much time they're facing, for instance. Well, if I tell a story in federal court because I'm facing a life sentence, which, by the way, the judge across the street had cut our feet off on. And we now know that that's going to be reversible error because the federal Sixth Circuit has ruled that you cannot hinder our ability to ask those questions. Well, later today, they're going to ask this court to do the same thing in a few moments. So we want to be able, or I want to be able on behalf of Bean to say, hey, when you were facing a jury across the street, you said X, Y, Z, if it's inconsistent with what was said previously. And I think it's only fair that we be able to draw that picture and to try to sterilize it as if it happened in some back, office space or what have you, is a lot different than being able to give it the full gravity of what it is. They're the ones bringing this case. They had priority. They indicted us first. We could have been trying it and it wouldn't have been an issue. But once you try a case with issues that are so parallel, then that's something that we face the burden of what we're saying, and I think 2 of the motions that I'm joining Oral Timmons in indicate. It's a double jeopardy argument that's out there regarding this case. They are wanting their cake and to eat it too by saying, hey, witness, if you're inconsistent, they won't know that you're inconsistent before another jury. That's less than fair to us because that tenders or tampers down that fire, and that shouldn't happen, Your Honor.
Before you respond, let me just go ahead and give the other defense attorneys a chance to.
I think that sums up our position as well.
All right, Mr. Zamaki.
Same here, sums it up well.
All right, I'm sorry.
If the reference needs to be prior hearing with a jury present, then that's fine. That's not, I can understand that part of it. But getting into particulars of the federal trial or the fact that there was a federal criminal trial against these defendants and there was a federal criminal trial in which a jury, prior hearing with a jury present, that's acceptable.
I mean, I think that I think we'd be being disingenuous if we're just calling it a hearing in front of a jury. I mean, it's a trial in front of a jury, and I think that it being a federal trial does not somehow put into jeopardy or any kind of painting of the jury. I think that it paints an accurate picture of what was going on. Now, obviously, again, with regard to the verdicts and outcomes and things of that sort, there's not going to be any mention of that. But I think that not calling it what it was is not an appropriate manner of handling it. I think that we can call it federal trial. It was an impaneled jury, and I guess leave it at that. There's not a need to necessarily go much further into just calling it what it was, and we can just leave out as far as any verdicts, any of those things. We'll leave those things out. All right, next issue.
I'll go back to what Mr. Perry just mentioned. This I guess sort of has 2 components. It has to do with possible sentencing exposure. I think it's taken for granted, but I'll go ahead and make this on the record that there shouldn't be any mention of the possible sentences or what these charges carry in terms of number of years or anything like that. That's entirely improper under Tennessee law. So that's the first half of this motion. The second is we do expect Desmond Mills to testify. As council knows, he's entered into a memorandum of understanding that's a written memorandum in which he agrees to plead guilty to federal charges. He has pleaded guilty to federal charges, and he agrees to plead guilty to state charges. He agrees that his truth should be taken, that the prosecutors in federal court believe that his truth should be taken into consideration at his sentencing, that his sentencing will be set by a federal judge, that after his sentencing in federal court and his pleas in state court, that whatever state sentence he receives, it will be served at the same time as his federal sentence, and that he'll serve that sentence in federal prison. Obviously, all that's fair game. The memorandum of understanding should actually be admitted and could be an example for, could go to bias or motive or whatever else. This issue, the second half of this issue is litigated in federal court, as Mr. Perry mentioned, about what counsel was allowed to say and not allowed to say on both ends of the equation. They were allowed to ask whether or not Mr. Mills expected to receive, and Mr. Perry called it by its formal name, a 5K1 in federal court that would allow a federal judge to depart from their advisory guidelines on the case. They were not allowed to ask Mr. Mills if a federal judge could theoretically only give him probation on the case. At the same time, the state, U.S. government, was not allowed to bring out the fact that he was facing in excess of 20 years incarceration at the top end. So the question was, do you have this memorandum of understanding? Do you expect the truth to be taken in consideration with regard to your sentence? Do you hope the federal judge or the United States government recommends a downward departure at the time of sentencing, but they were not able to get into either the low end, which theoretically I guess would be probation, or the top end, which would be in excess of 20 years incarceration in federal prison. I think that's the appropriate tack to take with regard to Mr. Mills. Obviously, bias, impeachment, we acknowledge the memorandum of understanding goes to that. The idea that he expects or hopes for consideration if he testifies truthfully goes to that. The fact that a federal judge will determine his sentence goes to that. The fact that he hopes the federal judge will take into account his truthfulness goes to that. But as far as number of years and things like that, I don't think that's appropriate for this jury to hear.
All right, Mr. Perry.
Your Honor, across the street, we were forced to play a silly game during our examination of Mr. Mills. You're facing a lot of time, correct? You're facing a whole lot of time, correct? Instead of being able to say, under the way that you're indicted, you're facing 3 possible life sentences. That is the way that I've always been able to ask questions. That is the way that the Court of Appeals subsequently, in the case of U.S. v. Taylor, decided on February 5th, 2025, says that you're supposed to allow to do. And it also said that the way that our questioning was done by the judge across the street, or the way that we were somewhat tied in that case to questioning like that, not only gives a false notion to the jury, it gives a misconstrued and confusing question to the jury. Because if I ask that question, you're facing a lot of time. To be candid, Your Honor, if Your Honor gives me 10 days for contempt to John Keith Perry Jr., that's a lot of time. If you give me a life sentence, that's a whole lot of time. And so to be able for jurors to say that they can dissect that and come up with some kind of a view of what that bias would be, because I might not lie about 10, if I'm facing 10 days in jail. I might tell the whole truth and nothing but the truth. But if I'm facing a life sentence and a Department of Justice attorney is banging on the table saying, this is how you saw it, this is what happened, is it not? I might be inclined to change my story about how it really happened to how the Department of Justice might want me to say it happened. That is the difference in context, Your Honor, and out of fairness, we should be able to, and I asked the court that, I know that it would be persuasive authority and not binding authority, but because of the small amount of time that we were given on this particular issue, that if you're inclined to look at it in the government's way, that at least pull that Sixth Circuit case, because the discussion is spot on with what we're doing right now, trying to hinder our ability under the Confrontation Clause to fully examine the witness. We should be able to ask this question from top to bottom about why you are biased, and to ask these silly semantics about, you know, how much time you're facing theoretically versus being able to say you are avoiding possibly X amount of years is the way that question should be allowed. In that case, spells it out verbatim.
What's the side on that?
It's U.S. v. Taylor. I don't know, Mr. Stanley would have it.
Judge, it is now 127 F 4th, 1008. It's Sixth Circuit of February of this year. I'd offer the court a copy, except I have a lot of highlighting and notes.
That's not a problem. All right, Mr. Singer, did you have an additional argument?
Yes, Your Honor. Let me start with a couple of things. First, we received notice by email yesterday that the state intended to have address the court on motions in limine. Point out that there's a scheduling order in this court that required motions in limine to be filed by March 28th, which Mr. Haley complied with, and response is April 14th. So the defense is a little handicapped in the day before trial, the afternoon before trial, learning about these motions. I'd also suggest that the state's argument about the ruling in the federal court on this identical issue has some relevance for this court. It has no more relevance to this court's ruling, in Mr. Haley's opinion, than the verdict in the federal case has on the verdict in this case.
And I'll agree with that. I mentioned the ruling in terms of way to explain the issue. I am not suggesting that the federal court ruling in any way binds Your Honor or should be considered some sort of legal precedent for Your Honor to consider.
And it's a confrontation clause issue, Your Honor. So it's a constitutional issue. In addition to the Sixth Circuit's Taylor case, I would cite to this court the Tennessee Supreme Court in State versus Sales, that's S-A-Y-L-E-S, 49 Southwest 3rd, 275. It's the Tennessee Supreme Court in 2001. And essentially the law is that defendants have obviously a constitutional right to confront and impeach witnesses, and that impeachment, proper impeachment, includes demonstrating bias or promises of leniency. The court can put some limitations on, but the limitations have to allow the jury to have sufficient information to understand the potential bias or leniency that, in this case specifically, Desmond Mills has to evaluate his testimony. And here, Mr. Mills pled guilty in federal court to a civil rights violation resulting in death, and based upon his conviction, he faced life imprisonment. That's the statutory maximum. And of course, there's no parole over in federal court. His federal plea agreement, in exchange for his cooperation, although statutorily he faced life, the federal prosecution agreed to recommend no more than 15 years imprisonment for him. So it is a significant benefit and promise of leniency. And it is a commitment of recommending no more than 15 years. They can clearly recommend less. On the same day that he pled guilty pursuant to that plea agreement in federal court, he came over and appeared in front of Your Honor where his case was severed pursuant to memorandum of understanding that he has entered with this DA's office. And essentially, he is indicted on 7 counts over here, including a Class A felony, second-degree murder, where he's faced with a sentence of 15 to 60 years, and essentially he gets a pass. Under this memorandum of understanding, he will plead guilty after he is sentenced in federal court. He will plead guilty over here to something that allows this court to sentence him to the same sentence he received in federal court, which will be served concurrent with his federal sentence and will be served in the Federal Bureau of Prisons. In other words, based on his cooperation, this DA's office has essentially promised him that he will receive 0 minutes punishment in state court in addition to the federal punishment. And it is critical for this jury to evaluate his credibility, for them to know the exact amount of leniency. In the Supreme Court of Tennessee stated in the Sales case, I'll give a brief quote, "A defendant has the right to examine witnesses to impeach their credibility or to establish that the witnesses are biased. This includes the right to examine a witness regarding any promises of leniency, promises to help the witness, or other favorable treatment." Without this jury knowing what Mr. Mills faced based upon his conviction, or he faced in this court, and what recommendations of leniency he has received in exchange for his testimony, this jury will be unable to properly assess the credibility of his testimony, his motive for testifying, and any potential bias.
Mr. Samuel, before you sit down, if we start examining what Mr. Mills his exposure is over in federal court, aren't we then also opening the door to what the other defendant's exposure is over in federal court, which, obviously that's one of the, as far as the case law with regard to defendants and what kind of time they could be facing, that's always been something that the jury's not been privy to, not been involved in. And so would we not, by saying this is what one of the co-defendants was charged with, then now opening the door of saying what the defendants could be exposed to as well?
Certainly we will not in federal court, because Mr. Mills and Emmett Martin, 2 of the defendants who are not on trial, are the only 2 who have been convicted of civil rights violation resulting in death.
Right, but we're not getting into what the convictions and what the verdicts were. We're not getting into what the outcome of the federal court is. All the jury is going to know is that these individuals were in a federal trial, because that's what you guys wanted in your other motion, to be able to say that there was a federal trial. And then we're going to be talking about one of the people that was charged with this group now having that exposure of a life sentence. What I want to make sure is that we are not wanting one, as was said before, not wanting the cake and eat it too. That if the door's open with regard to what the exposure is, we can't come in after the fact and then want to try to limit the understanding that the defendants are faced with that similar exposure. And I'm not sure how the case law would accept that. So I just wanted to see if you had a position as far as that.
Judge, my position is, on behalf of Mr. Haley, we have no intent of talking about his sentencing exposure. If a jury makes an equation based upon and reaches a conclusion in their hotel room or in their deliberations room about what he is facing if he's convicted, I can't control that. What I think the case law makes very clear is that if the state, when the state puts a cooperating witness on, that in order to properly evaluate his bias and his promises of leniency, that counsel, should they choose, and believe me, I will choose, to examine him regarding the exact benefit that he anticipates receiving. And he has, frankly, avoided a recommendation that he spend the rest of his life in prison by cooperating and testifying. And without the jury knowing that that's what he has avoided, it is my position that the jury does not have sufficient information, as state and United States Supreme Court have said, sufficient information to evaluate his credibility based upon normal impeachment for bias, motive, and promises of leniency.
All right, Mr. Zimmer.
I will adopt what Mr. Stingle, whoever that is on Mr. Leffler's phone, I will adopt what Mr. Perry and Mr. Stingle said just then, and I will go to your question that you've been followed up with Mr. Stingle. What about the other defendants? I would say that, one, you could take care of that by way of a limiting instruction, because it really just goes to Mills's credibility and the benefit of the bargain of him coming in and cooperating. Or number two, not give a limiting instruction, and the defendant, Justin Smith, would take his chances on the jury concluding that he's facing an equal amount of time, without getting into the issue that Justice Smith was acquitted of all civil rights charges. In other words, I would be willing to take that risk of them taking that lead. Or you can give a limiting instruction. But I adopt Mr. Perry and Mr. Stingle's argument.
All right, Mr. Hagler, do you have a response?
Yes, sir.
All right, Mr. Perry.
And just brief, I want to make sure to emphasize the fact that Mr. Mills's agreement is a continuing cooperation agreement with the district court. In other words, he can't take the stand and retreat from the position that he shared over across the street, or he stands in violation of that agreement potentially, even in this forum, because he has not been sentenced yet in the federal case. He's incentivized. If I'm his attorney in the federal case, I'm definitely going to bring up the fact that not only has he testified here back in September, but he also testified in the Shelby County criminal court in April and May. We feel that he should receive extra credit under that 5K 1.1, and that does make it a huge incentive. But I wanted to make sure that the court, and I know the court did just as much federal work as I do, so that's a continuing agreement though. So that incentive for bias is still potentially there.
All right.
Yes,
All right, the court's going to take that one under advisement and look over the case law that's been presented on this. And before that witness testifies, the court will give its ruling on that position. Was there going to be, was it intended that this information was going to be used in opening statements?
I didn't necessarily need to go too deep into it. I will say something regarding measure the motive and bias of different witnesses, but not specifics regarding exposure.
I will be giving Haley's opening, and I can avoid this issue.
All right.
And
Mr. Zuma.
Other than they have a cooperating witness, that the more they cooperate, the better they do on sentencing. I'm not getting into life sentence and all that.
All right. So then I will go ahead and give a formal decision on that prior to that witness's testimony. We'll just reserve that issue and not delve into the details until that time.
In the first half of that, will you also find that any mention of state sentences and possible sentences in state court is irrelevant?
Correct. And I mean, I think the case law has been pretty clear as far as referencing these sentences, potential sentences, and with regard to the defendants in state court. So we'll go ahead and exclude those.
We're down to the last two, Your Honor. The first is there's been some filings. I can't remember if the filings themselves were under seal or not, but I don't think they were. There's a motion by at least one of the defense counsels, or maybe two of defense counsels, having to do with selective prosecution, arguing that these defendants were somehow charged because of their race. There were some filings under seal that asked for certain records. Your Honor found no evidence of that at all. The state would make a motion that any sort of reference to selective prosecution or race being the reason these defendants were charged is disallowed.
So, do you have Mr. Perry?
Yes, Your Honor. The motions were filed because under Tennessee state law, it's required as a predicate if we're going to make that argument. And as of right now, that argument has not necessarily been met the predicate that the court has ruled. We realize the court ruled as it relates to what the court had an opportunity to look at in camera. The only issue that I have with it being a motion in limine is that potentially the witnesses that can establish whether or not that was an issue and it might take the stand. And I don't want that to be something that perhaps if we want to address the court at that particular time or approach and say, Your Honor, based off of the answers to certain questions, we believe that we should be able to delve into this. And so I would ask that the court reserve ruling as it relates to an in limine motion. Particularly, I think that on one of the potential witnesses is the person who was not in fact indicted. And because of that, we feel that the court should be able to make that determination at the appropriate time. But to stop it as of right now, and to be clear, in my opening, I don't plan on drawing any reference to anything along those lines. I just would say that it should be something that perhaps could be ruled on down the road in the trial.
Mr. Sam?
Mr. Haley's position is that subject to the state opening a door along those lines, based on the court's pretrial ruling, that should be safe.
Mr. Dumont?
I will say that what you got in camera, because I trust Mr. Hagerman so much, I just assume everything is given to you. For you to make that ruling pre-trial that you didn't have the evidence in front of you to support that allegation. So with that, similar to what Mr. Perry said, depending on how the trial shakes out, I would say just hold it under advisement, because we're not going to be bringing up an opening argument or anything like that. But if something happens, we would like to revisit it.
Right. Well, I mean, I think the court has already given a ruling on that, and irregardless of what the ruling is, if there was something that opened the door that changed the landscape, then we could revisit it at that point. So we'll go forward, continuing with the court's previous ruling that where it stands now, there'll be no mention of it unless a situation were to occur to open that door. And if it does at that point, we all can approach and renew an objection, and then we can have a hearing if necessary. All right, next matter.
And this is a final one. This is something that's also litigated in federal court, but I think I can make this real short. As Your Honor explained to the jury when we picked the jury, people assume that Your Honor's read the whole file and all this, and we know that's not how these proceedings. Your Honor does not have access to all the information purposefully, so you can make fair and unbiased decisions. This incident occurs, and we can call it different things, but there is a traffic stop of Mr. Nichols. There is an initial encounter there at his car. Mr. Nichols then runs away. One of these defendants that's on trial was present at the traffic stop. None of the other two defendants were not present at the traffic stop. The two defendants, Mr. Dean and Mr. Smith, respond to the radio that we have somebody running who's been tased and resisted. They encounter Mr. Nichols along with Mr. Mills in a neighborhood just a tenth of a mile from the scene of the car stop. what happens, and there's pole camera and body cam video. After all that is over with, Mr. Nichols' car is searched. In his car, they find a small amount of marijuana, along with a even smaller, I don't know what the phrase, like a residue sort of amount of a mushroom. I can't pronounce the scientific name, psilocybin, I think. A very small amount of the psilocybin with a small amount of marijuana. They also find in his car some documents. I'm going to call those maybe like identification documents. I can't remember exactly if it's a driver's license, but it's definitely like some sort of personal documents in other people's or other person or two's name. If it's a credit card or if it's an ID or whatever it is, it is. All this is found after Tyre Nichols is beaten. None of these officers have any knowledge of what's found in his car at the time. It hadn't even been found in his car at the time. So our motion is to stop any reference to the contents of Mr. Nichols' car, as it has no relevance to the mental state of these defendants or to the charges that are before the court.
Mr. Perry?
Yes, Your Honor. We have a case where, if you look at the very beginning of Emmett Martin turning on his blue lights for Mr. Nichols, it would have been at 385 and Riverdale, and he comes to a stop at Ross and Range. That's 2.3 miles away from that initial blue light. I think that the contents, to a certain extent, speaks to the res justi of Mr. Nichols. Your Honor, it's different than the standard case for several reasons. This is, to make these type of apprehensions is the job of these men that are on trial. Whether or not they caused the death of Mr. Nichols in the way that the state is saying, or in any way kidnapped him or had official misconduct, etc., those are things that the jury should be able to make the assessment of and at the end of the day rule on. But in order to do that, they should also have a complete picture, not of necessarily what is in the minds of the defendants, but equally what's in the minds of a person who has, and I think that it was danced around a little bit, but there was several identification and several credit cards that were stolen. And those are the things that at least go to the res justi of why this person, in essence, avoided being stopped on 3 different occasions. He avoided it in the car, ignoring the blue lights and siren, ignored it on the first scene when he breaks away. He goes to another scene, is apparently disposing of things at that second scene, and then is finally found at a third scene by Mr. Bean, and when he makes eye contact, he runs. So those are things that should be a complete picture. Now, I understand if the court says you shouldn't want to go into, personal belongings or this, that, or the other. No intent on that. But if, in any case, there is res justi, if it was the converse and Mr. Hagerman was prosecuting a person for whatever reason, that criminal defendant, based off of whatever it is that he had in his vehicle, that becomes a subject of why that person might be fleeing. In any case, and in this particular case, res justi is central to it. Now, I think that if it was something that they really wanted to argue and fight about, we should have argued this back if it was filed at the time that the deadlines were, and we could develop those arguments with a number of, of cases in case law. But here, it's clear that if you got what he didn't want to mention to the court a second ago, stolen credit cards and stolen IDs, that would give anybody a motive to try to avoid being apprehended. And that is a central issue. We're not only standing here asking whether or not what was in the minds of these individuals, but it surely should be a question, out of fairness, what's going on in Mr. Nichols' mind at that time, and that question mark is somewhat answered from our perspective. Now, if the jury says, hey, I don't think that matters, then that's their purview. They can weigh the facts, that's what they do. But in order to give some kind of a misconceived notion that he's just driving home and just says, hey, you know what, I'm gonna do Dukes of Hazzard, I'm gonna keep on riding away from blue lights, that's disingenuous. And it's just not fair. And we're asking that if the court says you want to avoid the things that are irrelevant in the car, that might just paint him in a bad light, we understand that. But specifically, the items of credit cards and things that are along those natures that are found in the car, we think that, and I think it's clear they're stolen. I don't think that they're gonna stand up and say they weren't stolen. But as long as we can establish the fact that these are stolen identifications, credit cards, etc., I think that it's open game, young.
Well, you said one of the things is disposing of things.
Yes, and 6705, 6705 Ross Ridge, it becomes clear that he is, yeah.
All right. All right, we'll go ahead and Mr. Shangle.
Judge, to be clear, it's not the entire contents of the car that we are trying to get in. It is the psilocybin mushroom that was seized, and it is identifications of two individuals that was stolen. It wasn't just somebody else's ID and credit cards. We can establish that it was stolen. As a matter of fact, for one of the IDs and several of the debit and credit cards, there is a police report from the day that it was stolen. The owners of these IDs and credit and debit cards will testify that they were stolen, and they have no connection to Tyre Nichols, and there is no way that he had authority to be possessing these things. The introduction of them for this jury's consideration is important because it tends to negate, if the jury so chooses, or counteract some statements that Mr. Nichols made that they will hear at Ross and Raines on the video. He says, I didn't do anything, while he's in possession of controlled substances and stolen property. He also says, I'm just trying to go home. The video makes clear he is not directly going home, and this video at 6705 Ross Ridge, he is seen slinking around parked cars and hiding, disposing of things and hiding from passing cars, one of them being one of the Scorpion Unit cars that drove by. So in addition to tending to negate, from Mr. Haley's perspective, for the jury to do what it wants with those statements, it also goes to the lawfulness of his detention. In addition to the lawful traffic stop for traffic violations that Mr. Nichols chose to make 2.2 or 3 miles from where he was blue lighted, it goes to the lawfulness of the detention after he's fled 3 times at Castlegate and Bear Creek. Mr. Haley's charged with 2 counts of kidnapping, and his detention was lawful not only from his flight, but from his possession of stolen property and controlled substances. And finally, there has been suggestion that the officers who made statements about Mr. Haley's strength and ability to resist and avoid being handcuffed were lies. His continued flight and his continued failure to cooperate and resist may well be explained in part by the possession of stolen property and controlled substance as he is pulled over by the police.
Judge, I don't have a lot more to add other than maybe a different take on it. This is probably one of the clearest examples of race gesti you're ever going to run across. Because as soon as Mr. Nichols ran off, ran from first blue light, then ran from Raines and Ross, then hid at 6705, and then ran from Bean, the question is, why is Nichols running? Of course, the jury's going to be able to determine, oh, he's scared of all police officers, he just wants to go home, or he wants to get away from that car. So that's res gestae to complete the picture. Now, this court can limit some of the, I mean, we're not getting into the other predilections that are in that car. Okay, we're looking at items of crime. Mr. Heiger might say small amount of psilocybin, but it's a Schedule I narcotic. It's felony. He has to get away from that car. If he gets away from that car, gets away from the cops, then he doesn't get linked to it. Now, so instead of talking in ambiguous terms about the credit cards and debit cards, not only were there police reports regarding these specific credit cards, debit cards, photo IDs that were found in Tyre Nichols' car. It was part of a break-in that occurred on October 31st, the night of October 31st, Halloween, and the early morning hours of November 1st, just a few months prior to this, okay? But what's interesting is the person who pled guilty to breaking in these cars and stealing the very items that are found in Tyre Nichols' car was captured November 4th. So I think it's more than fair to say, no, wait a minute now. How does this fella who admittedly broke into these cars and stole these credit cards and debit cards get those in Tyre Nichols' car within that short 2 or 3 day period? But then further, Your Honor, this court needs to take into account that when the TBI and the district attorney gathers up these stolen credit cards of, let's just say Martin Zumach's American Express card is in the bottom of that car, instead of calling Martin Zumach up and saying, we have a police report here that says you lost your American Express card, we may have found it. Instead of doing that, they gave, I almost said returned, they gave Zumach's credit card to a third party. And we should be able to explore that as it relates to how this investigation unraveled. All they were doing was focusing on convicting these people instead of looking into what was going on. So this is the clearest example of res gestae we're ever going to see. Mr. Nichols had every reason to run, hide, fight, flail, to get away from that car. And so, Your Honor, to limit us, and by the way, I would hate if we keep referencing rulings of the federal court and complicate error by trying to mimic it over here. The reason res gestae, you might as well say it, the reason the res gestae argument did not win the day in federal court is because there is civil rights case law on point that says once something is found later, it's not relevant because it's the police officer's state of mind at the time they came into contact with the defendant, whether or not they used unreasonable force. I didn't like the order of the court as it relates to res gestae, but that's not what we have in this case. We have common law murder. We have kidnapping. We have every reason to look at the victim and what he had going on in his mind at the time he's fighting, fleeing, and getting away from these police officers and dumping stuff on the side of the road. So I believe to paint the picture is fair. If you want to limit the instruction that we're not going to use it to, bash Tyre Nichols, I surely understand that. But to then hide the ball from this jury when they have to figure out what's in Mr. Nichols' mind as well as what's in these cops' mind, I think would be unfair, Your Honor.
Okay, or statement, response.
This jury has to find the mens rea of these defendants. Mr. Nichols is not on trial. These items were found after all of this was over. I don't see the relevance of it with regard to the mens rea of these defendants.
Listening to the arguments that's been presented, obviously these items don't necessarily go to the mens rea of the defendants, but the court thinks that those items, not allowing those items to be discussed, paints an incomplete picture of what may have been occurring that evening. Obviously, the mens rea, the focal point is the mens rea of the defendants, but if there were circumstances that could have contributed to the events that led up to ultimately what fed into the mens rea of the officers, the court finds those to be relevant. Now, with the caveat that obviously Mr. Nichols is not on trial here. And so the purpose or the basis on which the court will allow for that information to come in is for that limited basis of being able to paint a complete picture. But we're not going to go deep into the criminality of what was going on, but simply that these things were discovered and can be inferred that this, can be argued, that this may have contributed to the behavior that led up and to the interaction that ultimately took place between Mr. Nichols and these defendants. So the court will allow those with just the admonishment to the defense attorneys that we need to make sure we stay on course and not digress from with the additions of these facts. Anything else from outside?
I think that's all the motion to limit, Your Honor.
All right. Defense.
You probably, just for housekeeping purposes, I think we discussed it. I filed a dual sovereignty motion, and I believe Mr. Stingle did the same. I don't want to just make that a throwaway motion, because it's not a throwaway motion. But at the same time, I think to save it for potential appeal, it has to be ruled upon by the court prior to beginning trial.
All right. And
I'll have Bean or Tennis in both, join in both, Your Honor.
all right. Well, being said, no, I have I have a motion that's been filed on behalf of Mr. Stengel. Mr. Leffler, do y'all want to give a brief argument with regard to this motion?
Judge, very briefly, we need a ruling. The Supreme Court, specifically Justice Gorsuch, in a dissent, said that there are limits to dual sovereignty. In that case, it was a dissent. In that case, they reaffirmed the dual sovereignty doctrine, but he said that there are limits. That case didn't reach the limit. This motion says that this case reaches the limit, and the limit, the reason it reaches it is because, and I attached some text messages between the district attorney, Mr. Mulroy, and his January 2023 pre-indictment contacts with the heads of the Department of Justice Civil Rights Division as they were coordinating two prosecutions. And I would suggest that that explicit cooperation means that this case has reached the limit, and double jeopardy does attach based upon the federal trial, and this case should be dismissed.
I don't know if I heard you. Do you have both my motion and?
I do.
Because I go into the Pettit doctrine along with that.
State, y'all.
We filed a written response to this back at the time, Your Honor, and as Mr. Stingle said, his opinion is a dissent, because the majority opinion affirmed the 150 years of precedence before the court that prosecution by dual sovereigns does not constitute double jeopardy. Cooperation or even coordination or talking or sharing or whatever between a United States attorney and a district attorney with regard to the case, it's not even the issue. The court, even in the dissent, states that if one of the prosecutions is basically a, quote, sham prosecution, not a real prosecution, but just some sort of strategic prosecution to bolster the other, then, again, the dissent would have a problem with that. Obviously, we're in full-blown prosecution. Here we are. There's no evidence that one of these prosecutions has been a total sham that would even meet the standards of, again, the dissent. As a majority of the Supreme Court upheld the doctrine of dual sovereignty.
Judge, the only thing I would add is we have not received the state's written response that Mr. Hageman just referenced.
Well, with regard to the motion, the dual sovereignty doctrine obviously has been in place for some time. obviously, I haven't seen anything looking over case law on that that would prevent the government or the state district attorney from being able to discuss, cooperate, coordinate, or anything of that nature that would somehow negate the ability to pursue those charges. Looking at these cases, obviously the defendants are charged both federally and in state court. The charges, though, differ in some regard. There's some federal charges that have been exposed to the defendants that the applicable state law, there is no applicable state law. And so it's clear to this court that they have an independent prosecution. The state has elected to go forward with the violations of the state law, and they have proceeded with their indictment. So the court is going to deny the motion, finding that the dual sovereignty is well established, and allow the state to proceed. Are there any other motions?
I think that's it.
That's it.
All right, we're going to take a brief recess before we call the jury in, but we will go ahead and stand in recess for about 10 minutes. Ladies and gentlemen of the media, if you all, while we're on recess and the attorneys of the parties are out, if we can just go ahead and turn off recorders while we stand in recess. But we're going to stand in recess.
Court stands to recess.
sorry it took us as long to get you all in here, but we are going to begin this trial on this matter. Before we do, as I explained to you through the jury selection process, we are operating under oaths. And now is one of those times and occasions where the court is now going to place you all under oath. So I can have you all stand and raise your right hand. Do you solemnly swear or affirm to well and truly try the issues that traverse herein, joined between the state of Tennessee and the defendants, Tadarius Bean, Demetrius Haley, and Justin Smith, upon a true bill of indictment charging the defendants with the offenses of murder, second degree, count 1, count 2, aggravated assault, acting in concert, count 3, aggravated kidnapping, count 4, aggravated kidnapping, count 5, official misconduct, count 6, official misconduct, count 7, official oppression, a true deliverance make and a true verdict render according to the law and evidence, so help you God.
I do.
All right, thank you. You can be seated. Now, ladies and gentlemen of the jury, before we begin the trial, I'd like to tell you a little bit about what's going to happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, the jurors, and myself will be doing during the course of the trial. Understand at the end of the trial, I will give you a much more detailed instruction on how you are to go about reaching your decision. But now, I simply want to explain how the trial will proceed. The defendants have been charged by the state of Tennessee with a violation of state laws. The document containing these charges is referred to as the indictment. It is important for you to understand that an indictment is just a formal accusation charging the defendant or the defendants with a crime and is not evidence of anything. The indictment will shortly be read to you by an attorney for the state of Tennessee. We anticipate each defendant will plead not guilty to these charges. They are presumed innocent and may not be found guilty by you, the jurors, unless after hearing all the evidence, the attorney's arguments, and the instructions of law, you as the jurors seated in this case unanimously find that the state of Tennessee has proven its case beyond a reasonable doubt. The first step in this trial will be the reading of the indictment and the response by the defense, followed by the attorney's opening statements. The state of Tennessee will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. Their opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for each of the defendants may make an opening statement if he so chooses. Again, if the defense so chooses, it will explain to you what it believes the evidence will be. Again, statements of the attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence, which is generally done through witnesses. Defense counsel will have the opportunity to cross-examine each of these witnesses. The evidence in the case will likely consist of physical exhibits, documents, and testimony of these witnesses. Now, the witnesses will testify by answering questions asked by the attorneys and the attorneys only. After the state completes its case in chief, the defense will be given an opportunity to present additional evidence if it so chooses. Remember, the defendants are not required to put on any evidence or even to testify. If any of the defendants do testify, then their testimony will be weighed just as any other witness's testimony is to be weighed. If any of the defendants choose not to testify, then I will instruct you that you cannot hold that decision against them and cannot speculate or make any inferences from that choice, as there are millions of reasons why a person may choose not to testify. The burden is always on the state of Tennessee to convince you that each of the defendants is guilty beyond a reasonable doubt. If the state does present proof, because the state carries the burden of proof, the state will have an opportunity, should they so choose, to put on additional proof that responds directly to that proof presented in the defense case in chief. This is known as rebuttal proof. After you have heard all the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are also not evidence. In closing arguments, the parties will attempt to summarize their case and help you understand what the evidence was presented. One of the final parts of the trials occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions in the closing statements, 4 alternate jurors will be selected, and the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in this case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide the rules of law that apply to this case. My decisions will be reflected in my responses to questions and objections the attorneys may raise during the trial, as well as in my final jury instructions. It is your job to judge what the facts are from the evidence and witnesses. You must then apply the law and my instructions to those facts, and from that application you will arrive at your verdict. Again, the state has the burden of proving the guilt of each of the defendants beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendants are presumed to be innocent of these charges against them, and this presumption continues throughout the trial and entitles the defendants to a verdict of not guilty unless you are satisfied beyond a reasonable doubt. Thus, a defendant is not required to prove their innocence, to have their attorney make any statements or arguments, or to produce any evidence. I will now explain to you some of the terms you may hear during the trial, as well as some things to consider during this trial. Reasonable doubt. Every crime is made up of parts called elements. The state must prove each element beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case, and an inability, after such investigation, to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. If you find the state to have proven each element beyond a reasonable doubt, you should find the defendants guilty. If you find that the state has failed to prove all or even one of the elements beyond a reasonable doubt, then you should find the defendants not guilty. You as jurors must decide whether the state has proven beyond a reasonable doubt that the defendants have committed the crimes charged in the indictment, and you must base that decision only on the evidence in the case and my instructions about the law. Considering multiple defendants, you should give separate consideration to each defendant. Each is entitled to have his case decided on the evidence and the law which is applicable to that particular defendant. Any evidence which was limited to a particular defendant should not be considered by you as to any other defendant. You can acquit all or convict all, or you can acquit one and convict others. If you cannot agree upon a verdict as to any of the defendants, but do agree upon a verdict as to one or the other of them, you must render a verdict as to the one or the other upon which you agree. Credibility of witnesses. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. Did the person impress you as honest? Did he or she have any particular reason not to tell the truth? Did he or she have a personal interest in the outcome of the case? Did the witness seem to have a memory of the events he or she testified about? Did the witness have the opportunity and ability to observe accurately the things he or she testified about? Did he or she appear to understand the questions clearly and answer them directly? Did a witness's testimony differ from the testimony of other witnesses? These are a few of the considerations that will help you determine the accuracy of each of the witnesses' testimony. In making up your mind and reaching a verdict, do not base any decisions on the fact that there were more witnesses on one side than the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified on one side of that point. Your job is to think about the testimony of each witness you heard and decide the facts. Circumstantial and direct evidence. Some of you have probably heard the terms circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as testimony of an eyewitness. Circumstantial evidence is proof of facts from which you may infer or conclude that other facts exist. I will give you further instructions on these as well as other matters at the end of the case. But keep in mind that you may consider both kinds of evidence, which are considered to be equal value in law. Notes. The court will not provide you a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be provided with paper and pens and will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be just as accurate as written notes. Should you take notes, these notes are to stay private and remain your personal written notes and used only by you in your memory and not used to convince others of a particular point. You should also not discuss this case amongst yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all the evidence is received and that you've heard all of my instructions on the law before you deliberate amongst yourselves. During the course of the trial, you will receive all the evidence that you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you might think to be helpful, or try to learn about the case outside of the courtroom in any other manner. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that is given by a witness. That simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusions from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer that question. Do not attempt to guess what the answer might have been, should that witness been allowed to give the answer. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind and you may not refer to that statement in your later deliberations. You may not ask questions. It is the responsibility of the attorneys to present the evidence, and you must base your decision only on the evidence that's presented to you. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about rules of law that should apply. In some cases, we will have a bench conference in the courtroom outside of your hearing where the attorneys will approach and we will discuss the matter. In some instances, I may ask you all to retire to the jury room while we discuss this matter outside of your presence. We will try to resolve as many of these issues in the morning before we get started and in the evening after you all leave, but I ask your patience because these interruptions are necessary points in the trial where we have to resolve some legal issues. In the long run, in doing so, we will save time for all of us. If after the deliberations, any of the defendants are found guilty of any offense, the court will set the punishment at a separate sentencing hearing, a hearing in which the jury will not be involved. This now completes my opening comments to you, but before I turn it over for the reading of the indictment, there has been a stipulation of facts as to the video and audio evidence entered between the state of Tennessee and the defendants, in which they have agreed that certain videos and audio evidence, in this case, is admissible and may be introduced and used without the need for any identifying or authenticating witnesses. Counsel has agreed that certain videos and audios are to be admitted into evidence as Exhibit 1. An exhibit to this an attachment to this stipulation lists the video and audio. These videos and audio have been, and some will be, as proof develops, copied to a flash drive and labeled individually. This flash drive will be marked as Exhibit 1 in this trial and pre-admitted into evidence. This stipulation will be read to the jury as part of these instructions. And the list of these stipulated videos is attached here too, and may be added or deleted from the trial as the trial proceeds. And this stipulation is signed by all parties for the state and each of the attorneys for the defense. We will now go to reading of the indictment. State. Yes, sir.
I remember y'all. Welcome to Memphis. The State of Tennessee versus Tadarius Bean, Demetrius Haley, and Justin Smith. It's indictment 2300241. All the counts start the same. State of Tennessee, Criminal Court, Shelby County, January term 2023. Count 1. The grand jurors of the State of Tennessee duly selected and paneled, sworn and charged to inquire for the body of the County of Shelby, Tennessee, upon their oath present that Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith, between January the 6th of 2023 and January the 11th of 2023, in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully and knowingly kill Tyre Nichols in violation of Tennessee Code Annotated 3913-210 against the peace and dignity of the State of Tennessee. And it's signed by the District Attorney General for the 30th Judicial District. State of Tennessee, Criminal Court of Shelby County, January term 2023. Count 2. The grand jurors of the State of Tennessee duly selected and paneled, sworn and charged to inquire for the body of the County of Shelby, Tennessee, upon their oath, presented Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith, between January the 6th of 2023 and January the 11th of 2023, in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully, knowingly, and while acting in concert with each other, commit an assault on Tyre Nichols and cause serious bodily injury to the said Tyre Nichols in violation of Tennessee Code Annotated 3913-102 against the peace and dignity of the State of Tennessee, again signed by the District Attorney General for the 30th Judicial District. I'll skip the top portion. They're all the same. State of Tennessee, Criminal Court, Shelby County. Count 3. The grand jurors of the State of Tennessee duly selected and paneled, sworn and charged to inquire for the body of the County of Shelby, Tennessee, upon their oath, present the Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith, before January 6th of 2023 and between January 6, 2023 and January the 11th of 2023 in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully and knowingly remove or confine Tyre Nichols so as to substantially interfere with the liberty of the said Tyre Nichols, and the said Tyre Nichols did suffer bodily injury in violation of Tennessee Code Annotated 3913-304 against the peace and dignity of the State of Tennessee. Signed by the District Attorney General for the 30th Judicial District. Count 4. The grand jurors of the State of Tennessee duly selected and paneled, sworn and charged to inquire for the body of the County of Shelby, Tennessee, upon their oath they presented to Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith, between January the 6th, 2023 and January the 11th, 2023 in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully and knowingly remove or confine Tyre Nichols so as to substantially interfere with the liberty of the said Tyre Nichols and the said defendants, Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith, possessed or threatened the use of a deadly weapon, in violation of Tennessee Code Annotated 3913-304 against the peace and dignity of the state of Tennessee. Again, signed by the District Attorney General for the 30th Judicial District. Count 5. The grand jurors of the state of Tennessee, duly selected, impaneled, sworn, and charged to inquire for the body of the county of Shelby, Tennessee. Upon their oath, present that Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith, between January 6, 2023 and January the 11th of 2023, in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully and intentionally or knowingly, while acting as public servants, commit an act relating to Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith's office or employment that constituted an unauthorized exercise of official power. The said defendants, acting with the intent to obtain a benefit or to harm another, in violation of Tennessee Code Annotated 3916-402 against the peace and dignity of the state of Tennessee. Cal 6. Now I'll skip not only the top part, but about the grand jurors being duly selected and paneled. They all read the same. Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., Justin Smith, between January the 6th, 2023 and January the 11th of 2023, in Shelby County, Tennessee, and before the finding of this indictment, did unlawfully and intentionally or knowingly, while acting as public servants, refrain from performing a duty that was imposed by law, or that was clearly inherent in the nature of the office of employment of the said defendants, acting with the intent to obtain a benefit or to harm another, in violation of Tennessee Code Annotated 3916-402 against the peace and dignity of the state of Tennessee, again signed by the District Attorney General for the 30th Judicial District. This is the last count. Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith, between January 6th of 2023 and January the 11th of 2023, in Shelby County, Tennessee, before the finding of this indictment, did unlawfully and intentionally subject another to mistreatment or to arrest, detention, stop, frisk, halt, seizure, dispossession, assessment, or lien that the said defendants knew was unlawful, and the said defendants being public servants acting under color of office or employment, in violation of Tennessee Code Annotated 3916-403 against the peace and dignity of the state of Tennessee, again signed by the District Attorney General for the 30th Judicial District. That is indictment 2300241, State of Tennessee versus all 5 defendants, Tadarius Bean, Demetrius Haley, Emmett Martin, Desmond Mills Jr., and Justin Smith. It is an indictment for murder in the 2nd degree, an indictment for aggravated assault acting in concert, an indictment for aggravated kidnapping, 2 counts, an indictment for official misconduct, 2 counts, and an indictment for official oppression, 1 count. It is signed by the foreperson of the grand jury, a true bill having been returned on January 26th of 2023.
Now, ladies and gentlemen, I noticed as he was reading the indictment, many of you were writing very vigorously. You all will have the copy of the indictment in the back for you all's review in case there were some things that you all missed. I know we just talked about you all not receiving a transcript. The indictment, along with all of the evidence that is entered as exhibits, will go back before you for your review. So I just wanted to make sure you all knew that beforehand. As with regard to the defense's response, Mr. Perry, on behalf of your client, Mr. Bean.
I apologize.
No, go ahead. How does he plead?
May it please the court, Your Honor, and before this jury, on behalf of Tadarius Bean, in relations to count 1, murder in the 2nd degree, aggravated assault, count 2, acting in concert, aggravated kidnapping, count 3, official misconduct, 2 counts, and official oppression, Tadarius Bean pleads strenuously not guilty.
Right. Mr. Stengel on behalf of Mr. Haley.
Thank you, Your Honor. And to the jury, Mr. Haley pleads not guilty to all 7 of the charges.
All right, Mr. Zumach on behalf of Mr. Smith.
Yes, Martin Zumach on behalf of Justin Smith, who pleads not guilty to all 7 counts of the indictment.
State, are you ready with your opening remarks?
Guess we didn't promise y'all air conditioning. No roommates though, right? 2023-0074. That's the autopsy number from the medical examiner's office. For a 29-year-old young man who was working at FedEx with his stepdad Rodney, who also worked there. His injuries, the medical examiner will say, blunt force trauma to the head. But it looks like a car, almost looks like a car wreck. Injuries that you almost see mainly in a car wreck. He calls it torsional injuries. Torsion. It's a twisting from a torque-like force. His head accelerating while his body is stable, like in a car wreck when you're restrained by a seatbelt, and your head accelerates so fast, whips back, and the twisting of that acceleration actually tears his brain and tears his brain from the skull. Except this 29-year-old didn't get these injuries in a car wreck. The proof will be that he got them by being beaten to death by 5 Memphis police officers. The young man's name, Tyre Nichols. How did this happen? How does this happen? 5 Memphis police officers beat this young man to death, tearing his brain from the skull. Does it happen because it's 5 monsters? No. No. Nobody's going to call them monsters. Absolutely not. It doesn't take monsters to kill a man, though. It doesn't take monsters to kill a man. You'll see for yourself how Emmett Martin, who delivers such huge blows, how Desmond Mills, who delivers the baton again and again, how Tyre Bean and Justin Smith hold and restrain Tyre Nichols while Martin's doing what he's doing, and how Haley runs up, kicks him. Some did more than others. Absolutely. But all 5 of these men helped in this terrible, terrible thing. No one's going to call them monsters. 5 men helping each other beat a man to death. How did this happen? How did this happen? Tyre Nichols, 29 years old. He's on his way home to eat. He's going to his mom's house. You'll meet her. Her name is Ravon Wells. Live in, I'm going to call it Hickory Hill. Y'all aren't from Memphis, but Hickory Hill is sort of East Memphis. A good 15 minutes from where we're sitting right now, away from the river. The river's Memphis's western edge. There's some big streets that run through Hickory Hill, like Ross and Rains. You'll hear those streets in this trial. Those streets will have commercial type businesses and fast food places and things like that. But off those streets are smaller streets that are residential neighborhoods. So this is an area of Memphis where people live. Houses and neighborhoods and cul-de-sacs and all that stuff. It's a neighborhood where Ravon Wells was living, and that's Tyre's mom. It's around 8, well after 7, but it's around 8, and Tyre's driving his car, and he's on his way home. This is where, and you'll see for yourselves, all the answers we don't have, nobody has. There's limited information, but you'll see the information that does exist about how this started. Presumably, and I'm not going to take issue with it because there's not proof one way or the other that we can agree on or that we can point to as hard proof. Presumably, Tyre Nichols is speeding. Emmett Martin is a police officer. All 5 of these men that are charged in this crime are police officers. They work together as part of a team that's called the Scorpion Unit. That's not a bad thing. It's data-driven policing. Okay, so they send these guys aren't assigned to a particular precinct. Okay, and they're not assigned to like homicide or something like this. They're assigned to what's called the Scorpion Unit. They're sent out to various areas that may be having a problem with whatever it is. I'll send unit out to make traffic stops and do sort of anti-crime suppression type activities. Okay, they're out in Hickory Hill that night. Presumably, and again, we'll see what we see. Emmett Martin catches Tyrese speeding. At some point, Emmett Martin activates his blue lights. Whether or not Tyrese saw that or not, we don't know. At some point, Tyre continues driving. Blue lights are activated. Who knows if Tyre saw it or not. Emmett Martin stops his blue lights, turns them off. Drives presumably faster to catch Tyre Nichols. Probably a distance of 2 miles-ish, give or take a little either way, on one of these main roads. So no twist and a turn, anything like this, one of the main roads. And he reactivates the blue lights. Emmett Martin gets out of his car, but there's also another car too, and that's Demetrius Taylor. Okay, he's another one of these police officers, one of these 5 police officers, one of the defendants on trial this week. He stops too. Tyre Nichols' car is stopped, making a left-hand turn in the left-hand turn lane at the red light, okay, on the main road, on the way to his house. Tyre Nichols' car stops. He's waiting to turn, left-hand turn, the left-hand turn lane. Martin stops, Haley stops, and this traffic stop, this, guess what I'll call it, begins. There's a couple seconds of the traffic stop that we're not going to be able to see, because what we see when we see this traffic stop is from a body cam. Most of our police officers wear body cams. Who's the 3rd officer on the scene, and he gets there real quick. So we're not missing 5 minutes or anything like that. He gets there real quick at the start of this traffic stop. He's also on the Scorpion team. His name's Preston Hemphill. He's not indicted in the case. You will see his body cam and this traffic stop for yourself. Not gonna look like any traffic stop you've probably seen before. You will see Emmett Martin rip Tyre out of the driver's side of the car. Tyre's by himself. You will see Emmett Martin extremely agitated. You will see Demetrius Haley extremely agitated. You will see Tyre Nichols thrown to the ground, yelled various things to him. You will see various commands: get on the ground, he's already on the ground, we're gonna break your stuff. He'll respond to them: you guys are doing a lot right now, we're gonna tase you. All sorts of stuff while he's there, and this is captured on body cam, okay? This is apparently a theme in the case. Then they pepper spray him. Okay, he's on the ground, he's surrounded by Hemphill, by Martin, by Haley. He has not thrown a punch or a kick, he hasn't had any threats or anything like this. He's being yelled at and threatened, and he asked them, you guys are doing a lot right now. And then he's pepper sprayed, but in a theme of this case, the officers managed to pepper spray themselves. Okay? So they're pepper spraying, they pepper spray themselves. When they pepper spray themselves, Hemphill's also threatening to tase him. This all happens extremely fast. You'll see it for yourself. Quick video. Tyre gets off the ground and starts to run away. He runs in the direction of home, but he starts to run away. When Hemphill tases him, but it appears the taser doesn't really make contact, or only part of it makes contact. So Tyre's able to take off running. This traffic stop is going to look very confusing, very fast, and inexplicable. You'll hear Martin say when he rips Tyre out of the car past his body, something about his gun, Martin's gun. Tyre has no gun. Something about Martin's gun. Like maybe when he was ripping Tyre out, somehow Tyre's body contacted Martin's gun. You'll later hear Martin tell different stories about what happened. In one version, you'll even hear him make up a story about Tyre trying to hit him. You'll see the video for yourself. Okay? And what's important, as I go through, I went through that for you, I want you to understand this because this is important. Whatever that first traffic stop is, the traffic stop I said you're not going to be able to make any sense of, where they're ripping them out of the car, throwing them on the ground, threatening them, pepper spraying each other, tasing them. They're not even charged with criminal conduct with regard to that. This story hadn't even started yet. They're not even charged with criminal conduct having to do with that. First, Tyre Bean and Justin Smith weren't even there. Okay? Now Haley was there. Martin was there. But they're not even charged with that first traffic stop. Because what happens next, is what we're here for this week. Tyre runs off into the neighborhood where his house is. This neighborhood, like some neighborhoods, not a lot really, some neighborhoods have a couple cameras in them, okay? In Memphis, these things were put up, they were called Skycop cameras. They're connected to a place less than 2 miles from this building that's called the Real-Time Crime Center. Okay, so their camera feed goes to the Real-Time Crime Center, which a floor in the Real-Time Crime Center has like 30, 40 TV screens with various camera feeds. Now, there's more cameras than there are TVs, so it's not like they're actually constantly monitored. But if something's happening, an officer can hear on the radio, for instance, Castlegate's one of the streets you can hear, and then an officer can access that camera, okay? This neighborhood has at least 2 of those cameras in it. You'll see one camera that shows Tyre, he's run from the scene, and you'll see him walking through the neighborhood. You'll see sort of one of these police cars drive by, and you'll see him hiding from the police, you know, ducking down between the cars, hiding from these guys. Looking closer to his house, there's another camera. And this camera, these officers didn't know about. This camera catches what we're here for. The camera doesn't have audio. Some of the officers' body cams, you can imagine it's hard to see stuff in body camera, hands, feet, and everything. But the body cams have audio. So you'll see some of the body cams, the officers that have body cams on, and you'll hear the audio from the body cams. What we're here for this week is what you see on the camera these guys didn't know about. Doesn't take monsters to kill a man. Took 5 Memphis police officers who were frustrated, who were mad, and who let adrenaline and anger overcome it. And we're going to watch it for ourselves. Camera has a swivel. This is in the neighborhood, Castlegate, 1/10 of a mile from where Tyre was pulled over, just hundreds of feet from where his mom lives. The call will come out that the officers are at this intersection right here, and an operator is going to swivel the camera over. All right, if you stop here. All right. So we're going to see 2 officers here. You'll see this video multiple times in this trial. It helps if you pay attention to the shoes of this man here with the white soles, because if you watch those shoes, you can tell what he's doing. That is Justin Smith, who's one of the defendants on trial. Tadarius Bean is the other defendant, who's sort of on top of Mr. Nichols right now. Okay? There's a 3rd and 4th man here that you're going to see in a second. It's going to be Desmond Mills, and it's going to be Emmett Martin. I'll let the video play for a while, but let me tell you real quick what you're what you're watching for. Bean and Smith right now, sort of on top of Tyre Nichols, definitely not delivering any sort of death blows or anything like that. Tussling or flopping him around, something. But it's Bean and Smith who are sort of on top of him. Okay? You will see Desmond Mills, and it may have already happened at this point, it's quick, goes to pepper spray Nichols again, while Bean and Smith are doing whatever it is they're doing. Okay? And in what I told you was going to be a theme in the case, guess what? Desmond Mills sprays himself. All right? So he sprays himself, and he's going to walk. He's going to take a break. Spraying myself in the eyes or whatever. I'm going to take a break from whatever this is. That leaves Bean and Smith on top of Mr. Nichols doing whatever it is they're doing. Okay? That point the video gets graphic because Emmett Martin is also there. And you'll see Emmett Martin walk up to Tyre Nichols as Bean and Smith have him pressed on the ground. And you'll see first what is a catastrophic soccer type kick to his head. Bean and Smith have him pressed down. You'll see Martin with a very strong kick to his head. Tyre sort of collapse a little further on the ground. And you'll see Martin kick him again in the head and in the face. You won't see Tyre Nichols throw a punch. You won't see him kick. When you hear the audio, you won't hear him saying the threatening words or nothing. He'll take the soccer kick to the head. He'll take the second kick to the head. At that point, Mills, the one that sprayed himself and walked away, he comes back angry. I'm gonna baton the fuck out of you. Smith and Bean hold in position on him, and Mills baton strikes Tyre's arm. He'll tell you himself, just because he was mad. 1, 2, 3 times. Bean and Smith have Tyre at that point up. One has one hand, the other has another hand. They've managed at this point, at some point before this, to get one handcuff on one of Tyre's wrists. So they have one hand, they have the other hand. And then Emmett Martin, 2 kicks to the head. He comes back. There's a small strike in the head, if you watch it closely, by Justin Smith, but it's not a death blow. What Martin does next, though, it's real bad. Smith and Bean hold the hands, and Martin to the face. You'll see Tyre's head snapping back and forth while Bean and Smith have his arms. 5, 6 hits. Finally, it's been 4-on-1, and Tyre is the smallest guy. Doesn't throw a punch, doesn't throw a kick, doesn't have a weapon. Finally, they've thrown him out on the ground. Well, it's over now, right? It's over now, right? I mean, soccer kick to the head, baton strikes just because you're mad, holding them while Mark's hitting. Because don't forget about Haley. Don't forget about Haley. Remember when Martin made that traffic stop, there was Martin and there was Haley? What about Haley? He's heard where these guys are, so he's gotten in his car and he's driven there. He gets out the car and yells, "Beat that man's ass." Literally jogs up, has to do a sort of little sidestep. Tyre's totally flat on the ground, 4 or 5 people on him at this point. And he just kicks him just to do it. Don't forget about Haley. And if that's not enough, Martin, I'll better come over there and kick him one more time too. Both big kicks. And at this point, there's even other officers. Let's watch it. That's Beam Smith. Tyre's on the ground. This is Emmett Martin. That was to his head. Beam Smith on top. That's to his head. Tyre's on the ground. Here comes Mills. I'm gonna baton the fuck out of you. Three strikes with the baton, and now you'll start seeing punches to the face. It's huge. It's 5 or 6 punches to the face by Martin while Beam and Smith have his hands. At this point, this is over, but here comes Haley. Kicked him. Martin kicked him. Stop. You watch that. You'll hear testimony that Tyre was the smallest of everybody out there. You'll hear that Tyre produced no weapon. You'll hear that Tyre threw no punch. You'll hear that Tyre threw no kick. You'll hear for yourself that Tyre does not say a threatening word from the start to the finish. Instead, because what did I tell you? Where this camera was? Hundreds of feet from his mom's house. You will literally hear him crying for his mom. Yelling for his mom to come. While that's going on. You'll hear the officer saying repeatedly, "Give me your hands, give me your hands." But then you'll hear Desmond Mills testify. He had his hands. Beam Smith already had his hands. We're just yelling that so we can keep doing what we're doing. And all 5 of these men, remember the law of criminal responsibility that if you help, it doesn't matter who throws the death blows or not. But also, remember the law that all 5 of them have a duty to intervene. They have a duty to try to protect Tyre Nichols after that soccer kick to the head. Or how about the kick after that? Or how about all the punches? Or the kicks at the end? They have a duty to stop that from happening, but not a single word from one of them. None of them. Not from Bean, not from Smith, not from Mills, of course not from Martin. You saw what he was doing. Nobody said stop, not even once. Not even one time. What do they do next? He's handcuffed. He is dragged, and I mean literally dragged, over to the side of the police car. That is a police car. They're unmarked police cars. And, yeah, over the police car and put on the side of it. Before the emergency personnel can come, because they are called for. They are called for. Before the emergency personnel can come, Tyre is handcuffed, absolutely unresponsive. He does not say a word, an intelligible word. He makes sounds after he calls for his mom. Unresponsive, on the police car. You'll see it for yourself. Haley. Remember don't forget about Haley, the one that runs up and beat that man's ass and kicks him. Goes over with his personal cell phone, takes a picture of Tyre so he can send it to his friends. And these men have a duty to protect him. They have a duty to protect him, so what do they do when the emergency personnel respond? Do they tell them, look, he's gotten some hits to his head? Nope. Do they even make up a story like he fell and hit his head? Nope. They tell the emergency personnel, oh, he must be on drugs or something. He got pepper sprayed. But not a word. Hey, check his head out. You saw his head snap back up and did. All they had. Not a word. And it goes on for minutes and minutes. The officers walk away. They motion, hey, take off your body camera. They set it on the side. But you can still hear what they're saying. Man, we hit them with so many pieces. That's what they say, that's what they call it. We were all rocking. Martin starts making up crazy stories about the traffic stop. He was driving on the wrong side of the road. He swung at me. While Tyre literally sits there on the camera. You'll also see him collapse over in handcuffs there at the side. Sits there dying. Not a word from any of these 5 men about hit to the head, trauma to the head, or anything. Did they wake up that morning? There will be no proof that they woke up that morning planning on killing somebody. Like I said, not monsters, but men, overcome by anger and frustration and overcome by the moment, who literally beat a man to death, and they all had a part. Can we agree Emmett Martin was the worst? Yeah, we can. But they all had a part, and they all had a legal duty to stop it. Tyre Nichols is the victim's name. We're going to ask for justice for Tyre. This happened because these officers were overcome, reason 1, and reason 2, because they didn't know that pole camera was there. Justice for Tyre. These men are reasonably certain that the Soccer kick to the head of the next kid. The huge haymakers while they hold them. Reasonably certain to cause death, that's murder second. Each and every one of them is criminally responsible for 2 reasons. They took part in it, but even beyond that, they had a duty to stop it. Aggravated assault acting in concert. 5 of them. They cause serious bodily injury. Yeah. Do they do it together? Yeah. Do they have a duty to stop it? Yeah. Aggravated kidnapping. Not talking about ransom notes. It's the illegal confinement, the false imprisonment of a person that either causes bodily injury, or the people doing the false imprisonment have guns. Well, they're Memphis police officers, they have guns. They're not alleged to have used the guns, but the fact they're armed is one of the elements of aggravated kidnapping. Is a police officer allowed to arrest somebody? Of course they are. Maybe even earlier they were allowed to arrest Tyre Nichols. But at some point, after that soccer kick to the head, or maybe after the second one, or maybe after that huge, huge shot that Martin takes, this ain't no legal arrest anymore. Tyre is purely and 100% a victim, and those men have him in prison falsely while they keep on hitting him and kicking him. Those men have him in prison falsely when he's handcuffed next to the patrol car, and they're not even telling the medical personnel about the head wounds. Official misconduct. They had a duty not to do this. Official oppression. They had a duty not to do this, and they put Tyre through hell. At the end of this, that's what we're going to ask you for. Justice for Tyre Nichols.
Mr. Perry, are you ready to present your opening?
I am, Your Honor. I am. Okay, please, the court.
Mr. Hagerman just described a relatively simple situation. Mr. Hagerman described a relatively easy case. If you look at an overhead camera, and if you start off with the notion that they didn't know that it was there, these trained men that on a nightly basis go out into the most dangerous areas of Memphis, do the most dangerous job in Memphis, are supposedly not aware that the cameras that they rely on in doing their job over and over again is not there. That is a got you moment. That would be okay if Mr. Hagerman had stood before you all, looked you in the eye and said that Darius Bean, as he's out there on this, be on the lookout for a person who has been tased, pepper sprayed, and overcame 3 officers. If he had looked you in the eye and told you Darius Bean has to hit start on his body-worn camera to record it, it would be close to not disingenuous if Mr. Hagerman looks at you in the eye and says, you know, that camera that's 100-something feet in the air doesn't really capture the story as well as the body-worn cameras, because you can hear the 59 times that he's asked to give his hands. If Mr. Hagerman does not describe the fact that while he's on the ground doing whatever he's doing, that Mr. Bean has just run 80 yards with 40 pounds of equipment on, trying to capture somebody who made eye contact with him, and he asks him, hey man, and as soon as he gets the word man out, he takes off running. It would be an easy case if that night they didn't report to work on Flickr and discuss the fact that they had a spike in crime in that particular area, and that's where they're going to.
They say their prayer and they get out of there and they go to those particular areas because their work is important work. Police work is dirty work. It just is. It doesn't mean that the men are dirty. And he continues to say, I'm not calling them monsters. He can't call them monsters because y'all got common sense. He can't call them monsters because the evidence does not bear the fact that these men are monsters. I will start with what I agree with. I agree with the fact that they left Flecker going to East Memphis. I agree with the fact that there was a person seen speeding, a suspect. I agree with the fact that this person drove 2 miles after Emmett Martin, who delivered blows, etc., cut on his blue lights and his sirens. What I don't agree with the fact is that there is a mystery regarding why he was ripped from a car. When he decides to drive 2 miles away from blue lights and sirens, it is high risk. These men are trained to engage in high risk situations. And when you are engaging in a high risk situation, you cannot go up to that window and say, ma'am, please get out of the car. You just can't do it. You get the person out of the car based on your assessment of that situation, based on your training. It's that simple. He does that. Now keep in mind, whatever happened on that first scene, getting him out of the car, that he was sprayed and et cetera, let me tell you what he wasn't. He wasn't hit. He wasn't punched. Nobody pulled a pistol at him and said, I'm going to blow your brains out. He wasn't tased until he got up and started running away from these officers. So let me be clear. While that stuff is happening, let me tell you who wasn't there. Tyre Bean. Tyre Bean is 3 miles away with Demetrius Mills, who you'll hear from probably today, on another stop with a guy with a warrant. And just like the other 400 odd arrests that he had made over the last 365 days, there wasn't an incident with it. He's making an arrest because the guy had warrants. He's doing what he's supposed to do. And guess what they do? They hear a call out over the radio, and this is a very important point. There is no back room, back alley type of let's go behind closed doors and everybody throw the body worn cameras. We're going to give them some 1960, 1970 type of justice. This is a call out over the radio by officers. Man has been tased, pepper sprayed, approximately 6 foot tall, 6'2" it turns out, and weighed about 180 pounds. So he might be the smallest out there, but I have news for you. That's an SEC wide receiver size. That's the size of a person who's athletic, who has the ability to run and to overcome 3 grown men. It's that simple. So the fictionalized stuff will stop this week. And you'll have the ability to listen and to assess the situation. And you will be able to assess it like you're doing it on a January 7th cold night at 8 o'clock, rainy night, ground wet, and guys that only want to make it home to see their families and loved ones doing the best job that they can do. So, while Tyre Bean is on this site and they're about to arrest a person who's in custody, who they're making small talk with, and he's saying, yeah, you got me, I knew it. What do? They have to let him go. Because when you hear that bolo call, when you hear your person who you just had prayer with and just talked about going out into the world to do what you're supposed to do in the city of Memphis, when you hear somebody say he's been tased, pepper sprayed, and he's got away from you, it tells you one thing. It's danger. Let's go. And so what do? They go. They drive that 3 miles and they start trying to do their job. You will see evidence that's clear that Tyre Bean, they said, well, you know, they didn't have a talk about trying to hurt somebody. It's just the opposite. They didn't want to hurt anybody. They want to make it home. They want to be safe. And they want to do their job effectively. And that's all you're going to hear about. So at 8:32, the first interaction that Tyre Bean has with the person who subsequently will become Tyre Nichols, he makes eye contact with him while sitting in the passenger seat of a 2-man vehicle. And he does what he has to do or he'll get fired. He doesn't have the option to say that this person on the bolo who just took off running, that, you know, I need to figure out if he's got a pistol. I need to figure out if he's got a knife. I need to figure out what he's got. He doesn't have the ability to see 6705 Ross Ridge, and what you're all going to be able to see this week, Mr. Nichols hiding behind cars and leaving objects. He doesn't have that ability. So he doesn't know what he's left because, you know, unless he can have a crystal ball and say, hey, my job, I'm going to be safe, I'm going to make it home, all he has to do is to get out of the vehicle at that time and run like hell to try to catch this man on a dead sprint with 40 pounds worth of gear at night, and he does. Now, let me backtrack, because normally I don't try to talk about, and I know my friend Martin over here is going to talk about what Justice Smith does, but there's a telling point in this. Justice Smith drives up while Mr. Bean is driving down Ross Ridge, and in that area, ask one question: where he at? Which way did he go? Which way did he go? No conversations, no nothing, but he went that way because he knows that my partner in arms might be out there trying to apprehend this person negatively. And when they arrive on that scene simultaneously, and they take him down. Now, there is a 3-minute struggle. You'll get a chance to hear all of that. You'll get a chance to hear the body worn camera, but keep in mind that Tadarius Bean cut his camera on. So you're not trying to kidnap, you're not trying to ag assault, you're not trying to rob or murder or anything else somebody when you are recording yourself. You'll see you'll see Tyre Nichols do everything but give his hands. He reaches up. And does he get kicked down and then beat down and all that? No. They slap his hands 4 times, hands away from the vest of Tadarius Bean. And then they try to get him. Now, he talked about a recurring theme. This recurring theme of being pepper sprayed. Mr. Mills will come up, and Mr. Mills will testify about he pepper sprayed himself. If he's truthful and is consistent, he's going to also say, I pepper sprayed that whole area. And these other guys who didn't get a chance to go take a break and catch their breath and all this stuff, you know, you'll hear information about that first scene, and you're going to see Mr. Hemphill on that first scene. You're going to hear him hocking phlegm for an hour because he was pepper sprayed. He's not able to catch his breath, blowing his nose over and over. But during that time, who did not have the luxury to let this person go? Tadarius Bean. Tadarius Bean, and you'll hear about him. Graduated from the University of Mississippi, 2020. He goes to the academy in 2020 in August. January of 21, he graduates and he starts as an MPD officer. He was a patrolman too. He had no write-ups before that night. He had no complaints against him before that night. He had no issues or accusations of misconduct before that night. Had no verbal or written reprimands. He took his job dead seriously. He's assigned to Team 1 of the Scorpion Unit, which, by the way, is considered the best of the team in the Scorpion Unit. And he's the youngest member. And you'll get a chance to see what Tyre Nichols has done. And I don't want to get into Tyre Nichols prior to that night. I don't want to talk about who he was and all that. It ain't my business. I want you all to judge his actions. Consider the actions on January 7th, 2023. That he drove 2 miles away from blue lights and sirens. He was at Highway 385 in Riverdale. He drove all the way to Ross in Rains. You'll see that he ran from Bean after making contact. He refused to stop. He refused and resisted arrest. He was actively resisting the whole time. And you can ask the question yourself, does he have a right to do that? Does he ignore the lawful commands of the officers that are involved? Was he actively resisting by running and walking and pulling away from Bean? And you will get a chance to see the actions at 6705 Ross Ridge prior to the interaction with Detective Bean. Scorpion Unit, street crimes operation to restore peace in our neighborhoods. You'll see who it was, the brainchild of C.J. Davis, the chief. It was created in 2021. Consisted of 3 teams. And it focused on statistics related to crime spikes in certain areas. And Team 1 was sent to these dangerous places
to sometime execute warrants and things like that. It was effective. Knocked the murder rate down 18.5 according to Chief Davis. 18.5%. Went from 303 murders during the year before to 258. I've told you about the meeting on Flickr and what they did in the interim. You can go to the next one. You will get a chance to look at policy and training. You'll see MPD policy. You'll hear terms like active versus passive training. Passive resistance training. High risk stops. You hear testimony regarding the response to resistance policy of MPD, and you'll hear about hard hands. Now, kicks might not be the most tasteful sounding thing, but kicks are number one in the hard hands policy. It just is. And they followed the policy. You'll see the use of force continuum. You'll hear test questions that were given through the MPD Training Academy and how they discuss things like tunnel vision. When you're trying to look at a person and you're trying to hold on to them and you're focusing on one thing while other things might be happening. And you'll see training regarding the taser usage and when it's most likely to happen and when it's done the right way. And you'll hear about handcuffing. You'll see the difficulties of handcuffing a person who does not want to be handcuffed. And it will be consistent testimony that is one of the most difficult aspects of the job. It is what it is. You'll see aspartame usage training. Now, Mr. Mills might have buyer's remorse regarding it or whatever, but the fact is, on that particular night, he deployed his aspartame and he used it the way that they train you to use it. 3 strikes to the arm. If it doesn't work and give planning compliance, you put it up. That's what he did. Now, go to the next one. You'll get to weigh the witnesses. Some witnesses might not want to take a chance and they say, hey, you know what, I will do a plea. And that's their business. That is not in any way attributable to Mr. Bean. You can't say, well, he said he's going to do one thing and then talk about it, but you'll have an opportunity to weigh why Mr. Mills is testifying a certain way. And you'll get a chance to ask certain questions. But as it relates to Bean, the consistent thing will be there's never anybody saying that he's ever done anything wrong, illegal, that he used excessive force in any way, and there won't be much criticism of his actions on that particular evening from Mills or any other witness testimony if it's consistent with how they've given statements in the past. Next one. You'll also get to hear expert testimony. When you hear expert testimony, weigh it properly, is what we ask. And questions like, how many times have you testified as an expert? Is this the first case or the first facts that you've ever given expert testimony regarding? And then their knowledge of certain things like human factors, fatigue, tunnel vision, resistance level, body movements, center of gravity, those types of things. Those are questions that the expert will need to talk to you about. And you'll see videos. You'll see videos that were turned on by the body-worn camera of Bean, Mr. Mills' body-worn camera, and you'll then have a syncing mechanism where you'll hear the voices and see what's going on even with the sky cam. Next. During the time frame, there are 2 kicks, as Mr. Hagerman talked about earlier. And this is that relevant 3-minute period that they're struggling. 2 kicks, 3 uses of the aspartame, 5 strikes, all by people other than Mr. Bean. And then that window tightened, but it's the same amount. 3 hits with the aspartame, 1 with an open hand, 2 punches. The punches are done by Mr. Martin. And you'll see that we're talking about the punches happening within a 13-second window. So while they are holding one hand that's cuffed, one hand that's not cuffed, you'll have expert testimony about the danger of releasing the hands. Because if you release a cuffed hand or a hand that's uncuffed when a person has a cuffed hand, he has a weapon way more dangerous than anybody on that scene. The jagged edges of a handcuff can kill you. Now, this will isolate the actions taken, and it's just a demonstration of what you're watching from that scene and from the video as it relates to the movements made by Tyre Bean. It's just what you saw earlier. And you can write down the specific times that I ask you to give some focus to. That's at 20, 33, and 57. That shows that Mr. Nichols is blading his body. And it shows that Tyre Bean, while having been pepper sprayed earlier, is simply holding on to him. You'll see the amount of times that if he wanted to deliver some kind of punishment, that he could have punched him or kicked him or done something other than hold him, trying to get his hands into compliance and cuff. You'll also hear it as it's going on, as he's saying, give me your hands, man. Give me your hands, bro. Come on, give me your hands.
Can we approach real quick, Judge?
So a few seconds later, this is at 20, 34, and 12. Once again, look at where the hands of Mr. Bean will be. Now, the demonstrative is simply for you all to see, to give them a better sight of what to look for, not as any sort of evidence that'll come when the court allows. But look for his hand placements during that time. And that second later when Mr. Martin comes up and he does kick once at his head and once seems to land. This is when Mr. Mills comes up and he tries to deploy his asbaton. Keep in mind, you will get a chance to hear the video, the audio, and of the body-worn camera, and you'll see why they are placing their hands in the way and the angles that they are. Intended that is simply to try to avoid him getting hit in the head by accident, so he can have a clear shot at the arms for pain compliance, and you'll get a chance to see that. But that's 20, 34, and 56. That's when the first strikes from the baton is that was deployed. Second strike, as he turns his body a little bit more, is for that arm to be the target that's intended. You'll hear the evidence about how they are trained for baton placement when they're trying to make a person comply. Now, you'll have the opportunity to see how Mr. Nichols gets up, whether or not he stood up on his own or whether or not somebody stood him up. During this time, one of the hands have been handcuffed, the other hand has been freed. Mr. Bean has grabbed him by the waist, and that's at 20:35:08. At 20:35:09, I want you to look and be able to isolate how his body movement, in particular his center of gravity, and what he's trying to do, and you make that determination. But look for his body and his body movements and the center of gravity, and how it is pictured there is how it will picture on that video as Mr. Nichols continues to try to move away. At 20:35:10, you make the determination on whether Mr. Bean is trying to take Mr. Nichols back down to the ground, or if he's standing them up as the state has indicated. You see that center of gravity, and you'll look at it on your own, but remember those particular times because it tells the complete story. And that is one of the hands, as I indicated earlier. One hand is cuffed, one hand is not cuffed, but has the potential for him to be free, and that creates a danger for the officers, and you'll have an opportunity to view that complete video. And that just isolates what's at the top. So, you heard during Mr. Hagerman's presentation the sad realities of it. No one is here to in any way diminish the fact that a person's life was lost. Simply saying that that person's life was not lost because these officers had some bone to pick or some gripe or trying to do something punitive to this person. Simply trying to do their job based off of the information that they had. Mr. Bean only knows what came out on that call out. He only goes to that scene. He only strikes his hands during the time when he first arrives, and you'll see it on the body worn camera of both Mr. Mills and Mr. Bean. Mr. Bean has been pepper sprayed just like Mr. Mills, except he doesn't have the luxury of walking off for a minute and coming back like Mr. Mills did. If Mr. Mills says that he was angry regarding the fact that he wouldn't give his hands, and so he used the baton out of anger, only he can second guess himself. But that's not Mr. Bean saying hit him with an baton. More importantly, he hit him in the area that Mr. Bean was trained that Mr. Mills was supposed to have hit him in. Now, kind of glossed over it because it was on the PowerPoint, but you will see that the training under the conditions that these men faced, having been pepper sprayed, and having an active resistor, MPD policy and MPD training trains you to administer blows way worse than anything you've seen. The training of Bad Bob has never been in any way shown in the media or anything like that. You all will get to see it. And you will see how these men are trained under these conditions and what they are supposed to do under the conditions according to their training. And we're simply asking that you not create some account of the actions that they were supposed to have taken in the cool, calm light of this room versus men that are acting under their training and discipline on that particular night. And with Mr. Bean, I'm going to give emphasis to this as I sit down. Consider the fact that he had no prior incidents of anything. And on this particular occasion, he did not have the option to say, no, I'm not going to try to chase, and I'm not going to try to put handcuffs on this man. It's that simple. And I think that if you apply the law the proper way, all 7 counts will be not guilty. Men trying to do their job, and it's a dirty, hard job. Thank you.
Ladies and gentlemen of the jury, your lunch has arrived, so we are going to take a break for lunch. We will come back, we will finish the opening statements and proceed with the case in chief. We're going to go ahead and allow you all to step out. If you can please leave your notes in your chairs. Also, as we've talked about before, and we will say over and over again, please do not discuss the case with anyone. I know you've heard a little bit, but please do not talk about the case, even though you may not be intentionally doing so. As you talk about the case, you subconsciously start making conclusions about things. So please do not talk about the case. Let anybody talk about the case with you, and we will allow you all to step out with the deputies. Enjoy your lunch.